The recording's been started.
Thank you. Folks, thanks for coming. I've got a script. I want to make sure I check all the boxes and try to eliminate the ums and ahs as much as possible. Although if you've been in hearings with me before, they're going to happen. So just hang in there with me. We're now on the record for docket number 2021 OGR-01-001. It's now 1:03 p.m. Thursday, May 20th, 2021. We're at the Fruitland City Hall in Fruitland, Idaho. This is the time set to determine the factors I will consider when determining whether the terms and conditions of an integration order are just and reasonable, as provided in Idaho Code 47-321, for the spacing unit consistent of southeast quarter of section 10, the southwest quarter of section 11, the northwest quarter of section 14, and the northeast quarter of section 15, Township 8 North, Range 5 West, Boise Meridian, Fayette County, Idaho. My name is Mick Thomas. I'm the Oil and Gas and Minerals and Nav Waters Division Administrator, presiding over and conducting the hearing today pursuant to Idaho Code 47-328. I want to let everyone know that depending on how long this goes, we may have some spontaneous recesses that I'll call for 5 or 10 minutes to let everybody do whatever they need to do. Hopefully we can get this knocked out. We have the room booked until 5 o'clock, but if it goes over, we'll make additional arrangements. Before I continue, I want to let everyone know that I have reviewed all of the briefs and comments. I give equal weight to written and oral comment and arguments. As many of you know, the COVID-19 response has changed some of the typical aspects of a hearing of this type. The hearing is in person with a virtual Zoom component. This hearing is being recorded in Zoom as required by DAPA 0411-01651. We also have a backup recording device recording the hearing. For those on Zoom, please mute your microphones until you're called on. Please speak loudly and clearly when it's your turn. If there is a disturbance, you'll be reminded to mute your microphone. If the disturbance continued, you may be muted and or disconnected. For those of you watching this remotely, the material is broadcast via Facebook Live. Please visit our website at ogcc.idaho.gov site and click on the Watch Hearing on Facebook Live link. Documents in this record, docket number CC-2021-OGR-01-001, are on the OGCC website at ogcc.idaho.gov/administrative hearings. As my April 6, 2021 notice indicates, this hearing is addressing the scope of factors used to determine just and reasonable. I am not addressing today what terms are in fact just and reasonable. That is a question for a future evidentiary hearing held at a later date. I have allowed briefing and submittal of affidavits on the issue of the scope of factors used to determine just and reasonable, and I plan to take only argument at this hearing. Before I go any further, I want to address a request I received from the Dorsings to be admitted as a party. My understanding, based on the application and their request, is that the Dorsings are uncommitted mineral interest owners in the spacing unit in this matter. Given that, and that they have responded, they are already a part of the proceeding, this proceeding. You may participate in this hearing. Just keep in mind the focus is to determine the scope of factors I'll use to determine whether terms are just and reasonable, not whether a certain term or certain terms proposed are in fact just and reasonable. Also, I want to again clarify that the deadline for uncommitted owners to respond to this application has not passed, and they can still participate in future evidentiary hearings on the integration application. Witnesses and evidence may be submitted at that evidentiary hearing. We'll proceed with this hearing as follows. I will first hear arguments from the applicant, Snake River. This will be followed by argument from uncommitted owners within the proposed unit. Afterward, I will accept argument from the Idaho Department of Lands. Then Snake River will have an opportunity for rebuttal. After argument is complete, I will accept public comments. I will limit these comments to 5 minutes. I'll first take public comments from those appearing in person. I'll then take comments from those appearing on Zoom. I would like for everyone who speaks to state your name for the record. If you are here as a representative, please indicate your own name as well as who you're representing. I may ask clarifying questions while you speak. That said, will Snake River's representative please identify themselves for the record? Mr. Christian, since you're the first one here, I want to make sure that everything's operating. So, Chris, we're getting a little feedback now. What is it?
Yeah, I can hear that.
I think it was Richard.
If somebody else has joined to the conference in the room, yeah, we might need to mute.
I think we've got it resolved.
Okay, excellent.
Mr. Christian, say testing or something.
Testing.
Sounds good on this end.
Thank you. Please go ahead.
Thank you, Mr. Administrator. I'm Michael Christian. I'm the attorney for Snake River Oil and Gas, LLC, the applicant. Just as a preliminary comment, I'm going to spend some time on some things that you've already seen in briefing. I want to try to focus or bring some focus to the discussion. Then I'm going to spend some time responding to some of the arguments made by either the opposing mineral owners or the department. And if I'm redundant, I apologize. If you think you've heard enough of the subject and you want me to move on from it, please tell me. So I don't want to take up any more of your time than is necessary. As I think we're all aware, we're here to discuss what factors should be considered in determining what are just and reasonable terms of integration under the Idaho Oil and Gas Conservation Act. This is because of the decision in the Kaya versus Schultz case. The directive of the federal court in that case, in its memorandum decision and order in August of 2018, was to, quote, hold a new hearing that complies with due process by explaining the factors that will be considered when determining whether the terms and conditions of an integration order are just and reasonable, unquote. In other words, this process and the rounds of briefing that were made directly to the commission some time ago is perhaps laudable, but I don't believe at least explicitly required by Judge Windmill's order in Kaya versus Schultz. In fact, he stated in his memorandum decision that holding a new hearing will impose relatively few financial or administrative costs on the defendant. The hearing will involve the same issues, parties, and facts that the previous one did. The only change required will be the specification of the basis on which defendants determine factors to be relevant or irrelevant to the determination of just and reasonable terms. Before this, in his memorandum decision, he had described the case as a close one. In other words, that the amount of additional process that was due should not be extensive. And he had said that the commission has a significant amount of discretion to decide what just and reasonable means. He stated that his order did not affect the hearing officer's ability to exclude irrelevant or unnecessary testimony or evidence, or the commission's discretion to determine what facts should be considered when determining whether terms and conditions of an integration order are just and reasonable. In other words, what he appears to have intended was simply that an integration hearing would be reheld, but that prior to it, the commission or the department would describe factors that would be considered in determining just and reasonable terms of integration as an exercise of its discretion. So far, I think that is not what has happened. After multiple rounds of briefing and argument to the commission on the subject of what factors should be used, we've now engaged in more rounds of briefing specific to this application. And I think there was a previous application that was eventually abandoned where the same thing happened. And Snake River has filed another integration application beyond this one. And at this time, at least another bifurcation hearing has been ordered for with more rounds of briefing. This is not a process that is undertaken in any other producing state. I'm not aware of any other producing state that has a pooling or integration process that goes beyond essential economic lease and joint operating agreement terms, royalty, bonus, term, risk penalty, participation options, and the like. It would be a relatively simple task to describe a set of factors bearing on those issues. Now, as Judge Windmill said, the commission has a significant amount of discretion, and it has exercised it by choosing this procedure. I recite all of this to emphasize a couple of things. First, that what I think is an extraordinary amount of process has already been extended to participants in getting to this point. Second, that in deciding where and how far to go after this, I again respectfully suggest that the administrator and the department must keep in mind the stated purpose of the Oil and Gas Conservation Act and the scope of their and the Commission's authority. The Commission is not an all-encompassing regulator of all subjects. It does not police third-party contracts. It does not make economic decisions for operators. Its primary purpose is to encourage production while ensuring different interest holders are able to receive their equitable share of production while preventing waste. While it does have a role to play in ensuring safe drilling and production operations and protection of surface elements, that role is largely accomplished through existing requirements in the Act and the Commission's rules. This will not be the first time you've heard me repeat this, but the Act states that it is the public policy of the state to foster, encourage, and promote the development, production, and utilization of natural resources of oil and gas in the state of Idaho in such a manner as will prevent waste, to provide for uniformity and consistency in the regulation of the production of oil and gas throughout the state of Idaho, to authorize and to provide for the operations and development of oil and gas properties in such a manner that greater ultimate recovery of oil and gas may be obtained and that the correlative rights of all owners be fully protected. All of this is to the end that the greatest possible economic recovery of oil and gas may be obtained within the state, to the end that the landowners, the royalty owners, the producers, and the general public may realize and enjoy the greatest possible good from these vital natural resources. As I've described in briefing, correlative rights is defined in the Act to mean the opportunity of each owner in a pool to produce his just and equitable share of oil and gas in a pool without waste. I've also described in the briefing that waste is defined in the Act as being concerned with maximizing the ultimate production of oil and gas from a pool. Because the Commission was created by statute, our Supreme Court has held in more than one case that it has no jurisdiction other than that which the legislature has specifically granted to it. I think I cited due to the Idaho Power versus IPUC case in briefing. And the department, of course, is the administrative arm of the Commission. The Commission, as you know, is given jurisdiction and authority over all persons and property, public and private, necessary to enforce the provisions of the Act, and has power and authority to make enforce rules, regulations, and orders, and do whatever may be reasonably necessary to carry out the provisions of the Act. Similarly, the Act provides that the Commission is authorized, and it is its duty to regulate the exploration for and production of oil and gas, prevent waste of oil and gas, and to protect correlative rights and otherwise administer and enforce the Act. The Act directs that in the event of conflict, prevention of waste is paramount. All of this is in, most of it's in 47, 314, and 315. Although a thorough reading of Section 315 of the Act makes clear that the focus of the Commission's remit to encourage production, protect correlative rights, and prevent waste. There is reference to surface owners in 315 sub 2, but it's only as a modifier to protecting correlative rights by administering the provisions of the chapter that goes on. So, how does the Commission do this? How does this happen? First, the Act covers several subjects. Well spacing and drilling location requirements are set out in sections 317 and 318 of the Act. Requirements for setbacks are laid out in section 319. Royalty payment and recording requirements are provided in sections 331 and 332. Surface owner protections are provided in section 334. And second, the Commission promulgated rules covering drilling, well construction, well treatments, production, reclamation, and other operational requirements in IDAPA 20.07.02. It is useful, I think, in reaching just and reasonable terms to evaluate whether a proposed term or condition exceeds these requirements. In other words, if an operator proposes terms that are otherwise economically reasonable in comparison to those in voluntary leases in the area or joint operating agreements in use, or in other mature producing states, or as between the operator and its working interest partners, and the operator is subject to the operational requirements of the Act and the rules, as I've summarized, is it just and reasonable to require the operator to serve other requirements with respect to uncommitted mineral owners, which go much further? The opposing mineral owners in their briefing suggest that the term just and reasonable must apply to every other element of Section 320 of the Act relating to integration, apparently so as to permit anyone opposing integration to engage in an investigation and challenge of every other element, i.e. location, drilling, equipping, and operation of the well as part of the integration process. The statute, Section 320, of course, does not say this, nor is it necessarily implied. As previous orders have done, and virtually every integration of cooling order in every other producing state does, as near as I can tell, the order may simply, as the statute says, authorize the drilling and operation of the well and designate the operator. The details of drilling and operations are dealt with in the permit to drill issued pursuant to Section 316 of the Act, and under the drilling, casing, testing, treating, completion, metering, reporting, plugging, and other rules set forth in IDAP 20.07.02. To impose requirements differing from those rules would render them effectively a nullity, and to impose differing conditions in different units, far from bringing uniformity of regulation, as the Act calls for, would cause us to end up with the exact opposite, a hodgepodge of requirements varying by unit. This is obviously not what the Act contemplates or intends. Moreover, these are specific outcomes. They are not factors to be considered. And as such, I think they're beyond the scope of the hearing. In any case, there is already in multiple ways, ways mineral owners can participate more deeply in operational issues. First, as provided in the Act, under an integration order, they can elect to participate in the well, sign the joint operating agreement, in which case they can be on equal footing with other working interest partners who invest in and take on the risk of the well. This is a difference between a participating interest and a royalty interest. Second, they also have existing avenues for relief if they think an operator is violating the Act or the rules. They can file a complaint with the Commission, for example, under Section 328. One indication of what the integration statute is intended to address is the limitation of persons who may participate in the integration process, uncommitted mineral interest owners, per Section 328(3)(b), which led to my objection briefing to Kaya's participation because it's not an uncommitted mineral interest owner. That means, contrary to the opposing mineral interest owner suggestion, that those who do not own an uncommitted mineral interest in the unit are not subject to participation as parties, not mobile home park residents in the unit, not other people who do not own mineral rights in the unit. The suggestion near the end of the opposing mineral owner's opening brief that just and reasonable terms should be based on the input of all property owners, not just mineral owners, and I think that's a quote, with notice and expansion of the proceedings is contrary to Section 328(3)(b). And again, this is a specific outcome, not a factor. I don't think this is even the venue to argue about whether the factual assertions that the opposing mineral owners make in support of that position are true. Those are issues, I think, for the legislature of anyone. The procedural due process arguments the opposing mineral owners make, essentially that the entire process should be made even longer, should involve subpoena power to the mineral owners, and should involve the department engaging expert to investigate market conditions and the quote, viability of collection, processing, and transmission facilities are, again, directly contrary to the Act, and again, are specific outcomes, not factors. But they also completely ignore Judge Windmill's decision in Kaya versus Schultz, wherein he said, again, it was a close case and that the only change necessary to meet due process requirements was to tell uncommitted mineral interest owners ahead of time what factors would be considered. This is an exercise of discretion by the Commission and the department, and the opposing mineral owners would take virtually all of that discretion away. As an aside, the characterization of the opposing mineral owners at the beginning of their reply brief that Snake River is offering awful, miserly, or nearly irrelevant compensation terms and trying to avoid all accountability for harms are beyond not being factually supported at all, just wrong, and I don't think helpful to this discussion. Most of what they leave out of their argument completely is the interest of the other 90% of the mineral interest takers in the unit that have expressed through leasing their desire to develop their minerals and receive the benefit of them. The integration statute exists also to protect the interest of the majority from the tyranny of the minority. And I don't think you can lose sight of that. In their reply brief, the opposing mineral owners cite a rate case from the Supreme Court at the Federal Power Commission versus Natural Gas Pipeline. It's a decision from the U.S. Supreme Court, and they cite it for the proposition that forced integration statutes could only survive scrutiny, constitutional review, in addition to addressing mineral recovery and correlative rights. They also include a requirement that the terms of forced integration be just and reasonable. The decision they cite to involves rates chargeable by a regulated utility in interstate commerce, not integration or pooling of mineral interests. The issue in the case was whether the rate allowed by the Federal Power Commission was so low as to be confiscatory and violated the charging utility's constitutional rights. Essentially, the court found that no property interest was taken by the rate granted by the commission, and no consideration of due process as a condition to a taking was even really reached. It has nothing to do with the issues here and does not stand for the proposition that the opposing mineral owners cited it for. Likewise, the citations to rate setting cases in the opposing mineral owners opening brief are not relevant here. The Act has specific provisions, and Judge Windmill's decision was quite limited in its scope. I'm not going to repeat for you the factors that we propose on behalf of Snake River, other than to comment that we submit that the factors can be fitted within the scope and purpose of the Act. And second, that they are still, I think, well beyond what is applied in other producing states with similar statutory schemes. In my reply briefing, I think I directed you to a couple of examples of pooling orders from Arkansas and Wyoming. Both have pooling or integration statutes, which are, if not identical, pretty analogous to Idaho's. In neither case does the order go anywhere near as far as the opposing mineral owners or the department would have you go. In fact, I went and looked earlier today on Wyoming's Oil and Gas Commission's website, and that form of order is a template. In every statutory pooling proceeding, that form of order is used. Printed it off. I think I have a copy with me, but and with blanks for the numbers, basically, for what royalty should be, what risk penalty should be, what bonus should be. But effectively, that's the form that's used. And it's consistent with the form of order from Arkansas as well. I think everything else that I have to say is set forth well enough in our briefing. I don't want to take up any more time. And I'll take any questions you may have.
Thank you, Mr. Christian. Hold on just a moment. I want to shut this door because I'm hearing some rattling back there and I'll come right back. I've got just a few more general questions for the audience that I wasn't able to address before I invited you up. Are the Dorsings in attendance today? Are they here via Zoom? Just want to make sure. Well, whether they speak up now or not, I just want to make sure they knew they were invited. Thank you, Mr. Christian. I have a few questions. You answered the first one, I believe, pretty well in the opening brief, but I'm going to put it to you because I'm going to ask the other parties the same question as well. Thank you for the information you provide in your brief regarding industry standards regarding just and reasonable factors. Could you share for the audience and for those on virtually what some of the industry standards are when setting just and reasonable terms?
That's a broad question, but okay. Well, there are a couple of things. For example, if you look at the forms of order that I gave you from Wyoming and Arkansas, there are forms of lease and forms of joint operating agreement that have been in use in those areas for some time and are accepted. That's one thing. So by analogy here, we have forms of lease that have been used in the we'll call it the valley generally across, call it 1,000 leases or so over the last 10 to 12 years. And we can draw information from those about what is just and reasonable in terms of what the market has been over a broad area. So for example, I would say 99 point something of the leases are at $100 or less bonus and an eighth royalty. There may be leases that have a slightly higher royalty in there. I'm sure all of them are in an instance where someone owned a large acreage area where they basically had buying power, where it was advantageous to the operator to tie up a much larger piece of acreage. But by and large, $100 and an eighth is the norm. Likewise, the form of joint operating agreement that has been used between, I think, each of the prior operators. I'm not sure about Bridge, but I know Alta Mesa and Snake River have used effectively the same form of joint operating agreement between themselves and their working interest partners across all of the operations in this area. And it's derived from an AAPL, American Association of Professional Landman form, standard form, which is used across the country. So the form that Snake River has proposed in this application, for example, is effectively the same form that they've used with their own working interest partners. So those are two elements where I think you can derive information either from what's broadly in use in the industry, locally or nationally, and what's the norm as between the operator and its royalty interest owner lessors.
Thank you. A few more questions. Should the factors used to determine just and reasonable terms consider the use of uncommitted owners' lands, including whether a wellbore or pipeline may physically cross the land of an uncommitted mineral interest owner? If not, why not?
It could, but I think it depends on proof of the impact to the owner. For example, it would be reasonable to ask whether it's just and reasonable to allow a 12-inch pipeline to go across an uncommitted mineral interest owner's front yard on the surface, because that's an example of an obvious physical intrusion impact. I think it's less so if you're talking about a wellbore that's directionally drilled and is crossing under their property 3,000 feet down, because there's no actual impact to their use at the surface, and there's no reasonable likelihood that uncommitted mineral interest owner who owns a quarter-acre town lot, for example, is ever going to do anything 3,000 feet underneath the surface. So it is somewhat fact dependent.
Thank you. Your brief says that the IDO proposes terms that go beyond the Act's purpose and would impose terms and conditions regarding subjects over which the OGCC lacks authority. If that is the case, would the scope of just and reasonable terms and ultimately an integration order be limited to economic terms and therefore not address unrelated proposed terms?
I think the vast majority of the consideration is economic terms, and that's what's reflected in integration or statutory pooling orders from other states. They are concerned with, again, correlative rights and prevention of waste, which is to say, making sure that those uncommitted interest owners get their fair share. They have their opportunity to receive their equitable share of the production. I think, following up on the last question you just asked, there are some operational considerations you could take into account. Can I run a 12-inch line across somebody's front yard on the surface? Well, I mean, to the extent it's not already answered by either the statute or the act or the rules, my argument and comment to you earlier was the vast majority of that subject matter is already covered by the act or the rules. The operator has to follow the act and the rules and how it conducts itself. And and I think I set out in some more detail in my briefing, there are notice and opportunity for hearing requirements and opportunities for surface owners or uncommitted mineral interest owners to participate over a number of different subjects. For example, I've got if an operator wants to engage in a well treatment, they have to give notice to a certain surrounding area, and those people have an opportunity, if they want to have a hearing and talk about it, or at least comment on it. When well permit applications are filed, they're posted on the department's website, and those folks have an opportunity to comment on it, and the department can take that into consideration. So I think that there's that the sphere of consideration into operational issues in an integration order is pretty limited. I don't think it's zero, but I think it's pretty limited because of the statute and the rules.
Okay, thank you. One follow-up question. If there are non-economic lease terms proposed, how should I reconcile that request with the argument you just made? The scope of factors should be limited to economic terms, at least predominantly economic terms.
I think you would compare what's proposed with mostly with what's already out there in the market. What have 1,000 voluntary lessors agreed to? And what have what's in place in the, I don't know how many producing units we have right now, maybe 6, but there've been more, what's in place in those areas that were successfully produced or continue to be successfully produced. Those would be 2 obvious places to look. So I guess what I'm saying is I guess the question is, what's the non-economic term? There are, basically how long the lease is going to be for. Is there an option, and how long should it be? That could also be dependent upon whether there's a well already in the unit or whether there's already a drilling permit proposed, for example. It would be reasonable for you to ask, I think, well, if there's a well in the unit, what should the primary term be? Because, assuming that the order gets entered and there's some provision for extension, for example, if it gets appealed or it's litigated or whatever, once it gets to the point where it is a final order, it's not unreasonable to say you, the operator, should turn the well on soon. But, those are factors you could take into consideration. But mostly, I think it is a comparison to what's in the market.
Thank you, Mr. Christian. Those are all the questions I have for you right now.
Thank you.
Next, I'm going to call on Mr. Piotrowski. Let's make sure Mr. Piotrowski, can you speak and make sure we all hear you and everything? It's good to see you.
I certainly can speak.
Okay, we're hearing you. Very good. Before you begin, I have a question. Could you please state who you represent and specifically parties within this unit?
Yes, I certainly can. I'm James Piotrowski. I'm here on behalf of Kevin and Marjorie Clevenger, Christina and Lynn Larson, as well as Citizens Allied for Integrity and Accountability in its representational role, representing its members in the unit, which includes the Clevengers and the Larsons. Mr. Thomas, you have a difficult job here.
Stand by, Mr. Piotrowski. Yeah, I apologize for that. I want to make sure that people in the audience can hear. I just had someone jump up, so hold your momentum. We'll get you right back.
Will do.
Now that's about as loud as he's going to go. If you'd like to walk up and hear better, you can. Okay, Mr. Piotrowski, go ahead.
Thank you. Mr. Thomas, you have been given a rather difficult job. And through no fault of your own, although through some fault of the oil and gas industry, frankly. You are asked to address, in this particular step of the proceeding, the factors that will be considered in determining just and reasonable. You are doing so against a background that gives you very little information, and that is not your fault. That is the fault of the fact that the American justice system has finally come to realize the enormous challenges posed to existing property law and constitutional law by the oil and gas industry, which and is doing so in the case of you and I, Mr. Thomas, doing so in a location where we are not well versed in these things. Mr. Christian has given some effort to presenting to you integration orders and integration proceedings from other locations. And normally that would be useful and helpful to you. However, again, we're doing so in an environment where you face the unique challenge that for whatever reason, over the last 100+ years, very few property owners have chosen, almost no property owners or mineral rights owners have chosen to ask the question, can you, the state, take our property and force us to sell it to somebody else? And so you're stuck with the situation in which the only guidance you have in addressing some of this is the very clear guidance from the United States Supreme Court that says that in circumstances like this, whether it is rate setting or integration, the constitutional requirement is the same as the statutory requirement. That is to say that the terms you set must be just and reasonable. And frankly, for reasons that escape me, despite a strong interest in constitutional history, nobody has over the last now 80 years gone back to the courts to say, well, what does just and reasonable mean in this particular context? It's a fair question. And it's a question we raise, and it's a question we will continue to raise. We, meaning my clients, the mineral owners in this case, my clients, the mineral owners in the other cases currently pending, and in general, the people of Idaho. So you have to reach this decision, Mr. Thomas, and you have very little to guide you. Now, I will do my best to provide you what I think is reasonable guidance and have done so. The process we're using to do this is also somewhat challenging. Snake River's lawyer is unhappy at the process that was chosen, but that process has been chosen by the Oil and Gas Conservation Commission. It was their decision to use this case-by-case approach. That was not the approach that they were forced into. It was not. It was an approach that was certainly considered by multiple parties, but it is the choice made by the commission. We are here today on this particular integration application, not through any fault of PIA, not through any fault of landowners, but by the fact that Snake River Oil and Gas chose to file this application at the time it chose. And so if there has been delay, if there have been difficulties, they are not the result of anybody else's conduct. They are the result of the conduct of Alta Mesa, Idaho, now bankrupt, and Snake River Oil and Gas, the current holder of the operational rights. So we're here, and the process of getting here was not the process chosen by any of the parties before you, except for Snake River Oil and Gas. So you're stuck with trying to figure out what factors should be included. And we think that, and we have presented in our briefs, our belief that that comes down to what we call implied statutory factors, although some of them are express statutory factors. The constitutional factors, which includes both procedural and substantive due process factors, and what I think we can go ahead and agree to call a separate category of procedural factors. I don't necessarily view them that way, but Mr. Christian in his response brief did view them that way, so we're happy to address them on those terms. And so I want to talk briefly about each of those categories because I think each of them is important. And I think each of them is going to be important to the future courts who finally get to do the job of deciding what does just and reasonable mean in the constitutional setting as applied to this process. So let's start with a short discussion of the statutory purpose. Now, there is an express stated legislative purpose. That is the statement that Mr. Christian and Snake River Oil and Gas routinely bring out, although they, for fairly obvious reasons, focus on only the first statement of purpose, that statement being the one that it is the public policy of the state to encourage production. But in fact, the statutory purposes go far beyond that and are express. Those purposes are relatively obvious. Clearly, if the legislature had anything in mind about what constitutes just and reasonable, it would be the things they actually wrote about in their own legislation. So that's relatively clear. But there are also unstated but reasonably assumed, I'm not even talking about applied, but just reasonably assumed statutory factors. The discretion of determining what these factors would be was left, not expressly, but by implication, as recognized by the federal district court, to the commission and the administrator. And a clearly required statutory purpose was the assumption that you and the commission would exercise that discretion in compliance with the law. The assumption was certainly not that you would step out and try to violate the law. And had that been the assumption, I doubt you would have taken the job. The assumption is you will do your best to perform your task while complying with all existing law. And that's hard where the law is poorly developed in this particular field. The factors for just and reasonable are still undefined. You have to figure out what they are. And you have to do so, unfortunately, in this context of insufficient prior determinations by courts as to what those factors should be. So there's the statutory purpose and the clearly unstated but nonetheless necessary statutory purpose of complying with the law. There are also implied statutory factors. And the implied statutory factors are fundamentally everything that relates to the relationship between a mineral rights lessor and lessee, other than the royalty rate and the bonus payment. The royalty rate is set by statute for uncommitted owners, shall receive a 1/8 royalty. The bonus payment is set by statute at the maximum level paid to a voluntary lessor. So you have no discretion to address those, which means that literally every other factor that might go into these terms is something that should be evaluated to determine its effect on whether the overall proposal is just and reasonable. Now, the legislature was not and cannot be assumed to have been expert in what are the terms that make up an oil and gas lease. And so that's why those factors are implied. They left that to you. And those are the factors, both the statutory purpose factors and the implied statutory factors that are set out in our brief. I don't wish to repeat them here. There are also what I'm going to call the constitutional factors. Now, it's important in addressing these to understand a couple of points that are not true. First of all, the uncommitted owners are not asking you, Mr. Thomas, to decide that any part of the statute is unconstitutional. That is beyond your authority in all likelihood. There's certainly an administrative law argument to that point to be made. And we are not asking you to make that determination. In fact, we are making exactly the opposite argument, which is to say that the statute is constitutional as long as the terms set in the integration order are just and reasonable. And it is not constitutional if those terms are not just and reasonable. So we are not asking you to find that the statute is invalid in any way. And so any assertion to that effect is simply incorrect. In fact, we're asking you to make sure that the statute is valid. Second, The court, the decision of the court in Kaya versus Schultz decided a relatively narrow issue and did so, and then fundamentally stopped. And that is the way courts in the Anglo-American tradition have always proceeded. It's a doctrine called constitutional avoidance. You decide a case, judges in America are taught to decide a case on the narrowest grounds you can, and then if that does resolve the case, don't go any further. And that's what Judge Windmill did in this case. He concluded that the failure to define the phrase just and reasonable was a due process violation adequate to invalidate the prior proceeding that was addressed in that case. And to fix that problem, he provided a particular remedy. And the court did not go on to address the many other due process arguments that the plaintiffs in that case had raised, because it wasn't necessary to do so. And this is how American courts work. So, satisfying the explicit requirement of the judgment in Kaya versus Schultz, that is to say, and as Mr. Christian did say, simply telling us what the factors are. While that is adequate to satisfy the requirement in Kaya versus Schultz, it would be extremely short-sighted to assume that that also means everything else under the broad rubric of due process of law is also satisfied. This is further demonstrated by the fact that despite Mr. Christian pointing out the nature of integration orders from several other states, he is unable to cite a single case from a federal court sitting as a constitutional reviewer that has said, oh yeah, these factors are acceptable and are adequate to satisfy due process. That's not his fault. He can't do that because, as far as I can tell, such a case does not exist. The question has not been answered. So, Mr. Thomas, again, coming back to where I started, you have the task of deciding it in the first instance. What does the Constitution require to make something just and reasonable so that the statute is valid? This isn't addressed in prior integration orders from Idaho. It isn't addressed in integration orders from other states. It isn't addressed in prior constitutional challenges to integration orders, either from Idaho or elsewhere, because they simply don't exist. Now, that may seem odd in an industry as big as oil and gas, in a nation as large as the United States, but I can assure you it's not odd. There are many issues that have simply never been decided, and yet we have to deal with them. So what do, your job in ensuring that the statute is valid and is validly applied in this and other cases is to look at, what are the issues that are going to be necessary to satisfy the law? We think you can break those down into three broad categories. One is the substantive due process categories, and those are expressed and have been developed to a very limited extent in what are called the rate setting cases. We think you have to address the understanding of correlative rights, not only as the right to produce and sell one's gas and oil, but also as the right to decline to produce and sell one's gas and oil. And then finally, you have to ensure that there's a procedure that'll be adequate, because ultimately there is and will always be a deprivation of property rights going on in this process. You will, if you enter an integration order at all, which you are obligated to do at some point, you will be telling somebody, we, the state of Idaho, are selling your property to somebody else. That's the nature of integration. So those are the three things I think to address. Not necessarily going to take those in order. In determining first the issue of correlative rights, Mr. Thomas, not surprisingly, as a representative of the oil and gas industry that doesn't have fee holding of any of these mineral rights, necessarily focuses on the rights of individuals to produce their gas. But the ownership of a thing includes both the right to sell it and the right to keep it. And so a proper analysis of correlative rights is going to include balancing of the rights of those who want to produce against those who think it's not the right time, those who think it's not a very good deal, those who think that it harms their property more than it helps it. And so the actual recognition of a right not to sell is an important first step in understanding what are you going to order be done when that right is denied. So, second, we should talk about the procedural methods here. The oil and gas companies want a fast, inexpensive, stripped down procedure that makes it harder for mineral rights owners to make a case for what are just and reasonable terms. But those procedural steps that we've requested are critical. I can give you a great example that we're facing already. While it is true that the vast majority of oil and gas leases in Idaho have been at a 1/8 royalty and a $100 bonus payment, we know, because Mr. Christian has told us, that in some cases a greater bonus payment was made. And I certainly, for one, appreciate his integrity in disclosing that. I have serious questions, however, about the integrity of the oil and gas industry. It's America in 2021. Everyone has questions about the integrity of the oil and gas industry. And if we don't have the ability to subpoena records, we have no way of proving whether or not a different bonus payment was made. We have no way of knowing whether or not Snake River Oil and Gas is trying to impose terms on mineral owners that it would never even accept for its own mineral rights. We have no way of knowing whether, in fact, Snake River Oil and Gas has the leasehold that they claim to have if we can't test the truth of their statements. And that's what this procedure that we're proposing is about. And yes, it looks an awful lot like a court proceeding, but that's the tool that American jurisprudence has chosen to test the truth of facts. So things like giving us adequate time to prepare, providing us subpoena power, providing us the ability to actively and, when necessary, aggressively cross-examine those who are making statements under oath to you are all tools for finding the truth. And that is also very closely related to the final category, which is to recognize the substantive rights of mineral holders. In addition to their right to decline, if they are forced to sell despite their right to decline, then the rate setting cases, which is very much what you're doing here, Mr. Thomas, you're setting a rate. It's not the royalty rate or the bonus rate, but it's everything else that goes into one of the terms of sale. The law on this teaches us that there are a lot of factors involved, and a lot of those factors are purely economic. It is hard to imagine a better example where the economic and the non-economic are actually identical. If you're going to force somebody to sell what is under their property, then the harm you do to the surface estate is an economic harm. If in the course of forcing someone to sell their subsurface estate or a portion of their subsurface estate, you destroy the value of their surface estate, that's an economic harm. If you force somebody to sell their mineral rights at a below market rate, then you are not only violating due process, you are doing economic harm. The fact that something is economic does not mean it is unimportant. It does not mean it doesn't have constitutional significance. In fact, it means quite the opposite. Where economic harm is done, the law of due process is always held. It is much easier to prove that there is a deprivation of an interest that requires due process of law. So the argument that this is purely economic and therefore somehow excluded from constitutional consideration wouldn't be more wrong. The combination of the correlative rights of non-consenting owners, the procedural tools that are used to find the truth and to protect the interests of everybody involved in a transaction, and the substantive due process rights related to ensuring that the overall terms of sale are fair and reasonable, are all related. And so you can't have one without the other. To that end, our position is a fairly simple one, if not an easy one, which is to say, we are about to engage in the process of telling people that we are going to take something they paid for against their will on terms they don't approve of, and we're going to sell it to someone else. This is an exercise of state power over people's homes. Let's not pretend otherwise. And that implicates fundamental rights at an incredible level. So to that end, the factors we've identified and the factors that the Department of Lands has identified are both highly relevant to determine what is just and reasonable. And finally, if you find yourself uncertain of which way to go, sir, which I wouldn't blame you for, we can go back to, literally and directly to the statute itself. What is just? What is reasonable? It is not just to come to somebody and say, I want to sell my gas, so I'm going to make you pay a price for that, even though you don't want to buy my gas. It is not just for a corporate oil and gas operator to come and say, we're going to shift the costs of our operation onto people who didn't want anything to do with it in the first place. It is not just to come to people and say, we're going to let these outsiders, these people who you don't owe anything to, come to your land, drill under your property, and if they happen to poison your groundwater, well, we're not going to do anything about that. Just and reasonable implies fairness. It implies a good deal. It implies that nobody is shifting their costs onto anybody else. And it implies that everybody who didn't want to participate in this deal that's being forced on them be able to walk away in no worse position than they are right now. When this is all said and done, everybody should be in a better position than they were before it started. And right now, with the terms proposed by Snake River Oil and Gas, we don't think that's the case, and that's what we think the upcoming hearing should address, how to make sure that that happens. As Mr. Christian admitted, whether or not, for instance, surface use of the subject estates is appropriate and within just and reasonable is highly contextual. It will depend on the facts on the ground. And so that is why you face this task of trying to decide in each case, one at a time, what is just and reasonable. Here, where the spacing unit includes both industrial and agriculture and residential, and I don't honestly remember whether this particular spacing unit includes municipal property, but where all of those things are in existence, then the factors to be considered should reflect all of those things. If this were purely a spacing unit that consisted of nothing but 640 acres of rangeland, it would be a different case. That is not the case we have, and the factors you choose should reflect the interests of everybody who will be affected, including the homeowners that are my clients here. I would happily stand for any questions.
Thank you, Mr. Piotrowski. I've just got a few questions for you, and then I'm going to have a courtesy 15-minute break for the people in the room and whatnot, and we'll come back. But let's go to a couple of questions first. First, with the people you represent, are they members of Kaya?
Yes, they are.
Thank you. And I'll pose this question to you. It's the single question I'm going to pose to everyone. Could you share what industry standards are regarding factors used in setting just and reasonable terms?
The industry standards, to my research, vary from place to place and are developing over time. The form contract that Mr. Christian continually points to and that is included as part of their application and is apparently the basis of the voluntary leases they've entered into is very broadly written and is written in such a way that it can address many different types of operations. And so, for instance, the industry standards in North Dakota will be different from industry standards in Western Pennsylvania. And those will be different from industry standards in West Texas. And those standards are highly contextual. Here in Idaho, those alleged thousands of leases that Mr. Christian speaks of, the vast majority of those were entered into by one company, Alta Mesa and its affiliates. And so it doesn't tell us much about industry standards here in Southwest Idaho. Those standards have yet to be developed here in Southwest Idaho. We have a handful of wells, almost none of them are in production. Those that have been in production have resulted in litigation, or at least one of them has. We don't have industry standards established in Idaho at this point. We have a company that came in and has tried to establish industry standards that are suitable to it and its profit margin. That does not make them actual industry standards. We won't have industry standards in Idaho until we have a lot more experience with what it's like to drill and produce here in Idaho. And so while generalized industry standards are helpful, they provide some level of guidance. One, I don't know how you'll find those standards, to be honest, because they are difficult to suss out. And two, they may still not be appropriate for our setting.
Mr. Christian, thank you for that. And with that, it's 2:05 Mountain Time. Chris, I'm going to ask you to pause recording for about 15 minutes so everyone can get some air, maybe a drink, and we'll resume at 2:20 Mountain Time. All right?
The recording's been started.
Thank you very much. Folks, we had a nice little recess, and as you saw, I tried to improve the speakers for some of those in the attendance. It didn't work, so we're just gonna, I think everyone can hear, and if not, you can feel these front chairs. We've heard from Mr. Christian, Mr. Piotrowski. Right now, I would like to call on the Idaho Department of Lands Council. For the record, please state your name and who you represent.
Thank you, Mr. Thomas. My name is Joy Vega. I'm a Deputy Attorney General with the Idaho Office of the Attorney General, appearing today on behalf of the Department of Lands Oil and Gas Division. The Idaho Department of Lands did file an opening brief in this matter. The stated intent of IDL's brief is to provide easy reference points to applicable Idaho code sections, administrative rules, and other contract-based considerations that may be necessary or relevant in establishing what just and reasonable factors, and related evidence may be considered at the upcoming evidentiary hearing. That evidentiary hearing will be on the merits of the integration application before you. At that evidentiary hearing, the applicant will presumably offer proof of its compliance with the statutory requirements that enable the integration of the uncommitted mineral interest owners pursuant to Idaho Code Section 47.320 and IDAPA 20.07.02. Additionally, through this process, evidence may be accepted as to what just and reasonable factors have been established as a result of this hearing. IDL's input on the identification of the applicable statutory and regulatory provisions matters because the Oil and Gas Conservation Commission has delegated most of its powers and duties vested by law to the department. IDL has authority and obligation to administer or enforce most of the provisions of the Oil and Gas Conservation Act, whether by express declaration of the legislature or delegation by the commission. The statutes, rules, and contract-based considerations identified in IDL's opening brief are each factors that it has identified as being necessary or relevant in the event a final order is issued integrating the uncommitted mineral interest owners in the spacing unit that was established, I believe in 2020 in Docket OGR-01-002. Section A of the Idaho Department of Lands opening brief addresses just a couple surface use factors that may impact integrated parcels. If a surface use of an integrated parcel is addressed in the integration order, the terms of the order may substitute or supersede the surface use provisions in the standard lease form that has been submitted by Snake River Oil and Gas at Exhibit D to the application. As an example, the application cover letter indicates that no drilling activities will occur on parcels to be integrated in the spacing unit. If that statement is presented with evidentiary supports in the integration hearing, the department recommends that such a limitation be included and made part of the actual integration order. Another example would be whether the applicant intends for other surface uses, so other than the drilling location, on any of the integrated parcels. If the evidence presented at the integration hearing is that no surface uses are expected on any of those integrated parcels, then that limitation should be made part of the order, which in turn would supersede certain surface use terms in the applicant's standard lease, including the Exhibit B to that lease form. Section B of the department's opening brief identifies 4 sections of Title 47, Chapter 3 that pertain to royalties. These are relevant factors to an integration proceeding because Idaho Code 47-320 provides that the department, quote, may prescribe the terms and conditions upon which the royalty interests in the unit or units shall, in the absence of voluntary agreement, be deemed to be integrated without the necessity of a subsequent separate order integrating the royalty interests. Since a function of the integration order can be to set the terms and conditions upon which royalty interests in the unit will be integrated, utilizing the minimum requirements of the Oil and Gas Conservation Act is an appropriate baseline for ensuring that an integration order includes terms and conditions that are just and reasonable. Of the 4 statutes listed, the Oil and Gas Conservation Act's definition of market value was included because Idaho Code 47332, subsection 4, which addresses reports to royalty owners, including deemed leased owners, requires that the gross production, disposition, and market value be stated on each oil and gas royalty check stub. Also, Snake River Oil and Gas, as the lessee, would have to maintain all reports and records that any integrated owner, as the lessor, may require in order to verify gross production, disposition, and market value of oil and gas sold from the unit. The first sentence of Idaho Code 47-310, subsection 11, defines market value as it applies to 47-332, subsection 4, which I just discussed. In addition, the second sentence of the definition of market value is also applicable to the royalty check stubs because 47-332-1I requires that the royalty owner's share of severance taxes be stated on the check stub. In the definition of market value, the legislature has limited what, if any, deductions can minimize that severance tax. So the just and reasonable terms of integration should include at a minimum applicable statutory requirements. So each statute that relates to the royalty interests of a deemed leased owner is relevant to the integration order and the contract's terms that would be imposed upon those owners. Finally, Section C of IDL's brief identifies some contract-based considerations that you may want to identify as just and reasonable factors for further discussion and presentation at the evidentiary hearing. The process of integration under the Oil and Gas Conservation Act imposes binding contracts on deemed leased owners. It is therefore incumbent upon the applicant and this tribunal to ensure that those contract terms at least comply with the statutory minimum requirements. In turn, it is incumbent upon the applicant and this tribunal to ensure that the imposed lease terms do not give the operator more than the right to develop, produce, and sell the oil and gas from the unit. If the standard lease form submitted as Exhibit D does not comply with Idaho law, the integration order is the tool for altering those form contract terms. Therefore, the considerations listed in Section C could be useful in enabling this tribunal to ensure that a final order granting the integration application impose contract terms on the deemed leased owners only to the extent permitted under Idaho law. If you have any questions, I'd be happy to address those for you.
Thank you, Ms. Vega. One question that I posed: could you share industry standards regarding factors used in setting just and reasonable terms? Again, Idaho, as everyone has said so far, is a new state to this. So a broader, I think, body of industry could help.
And I would agree, Mr. Thomas, that Idaho is a generally new state to oil and gas development. It has existed for, I think, over 100 years, however, not to any great economic value. However, that could certainly change. The focus of the department's review or consideration of industry standards is really focused on ensuring that those standards conform to Idaho law. Although I was not personally involved with the drafting of the Oil and Gas Conservation Act, my understanding from those who were is that other nearby Western developing states were looked to, and their laws were looked to, and their processes were looked to as to what works in our region. So if this tribunal needs to go outside of the Idaho Oil and Gas Conservation Act and the applicable regulatory rules and administrative rules, you could look at what other states in our region are doing based on what those states' laws are and whether or not they're very similar or very different from Idaho's. You could also perhaps look at what the Bureau of Land Management does in its standard lease. I believe it's standard across the country. However, there may be differences in regional lease forms, but those are things. So kind of these standard statutes that are used across most states, standard lease forms or terms that are used by the federal government or other state governments are terms that are common in the industry, generally accepted in the industry, and the application across state governments and the federal government is a normal understood thing in the industry, which also probably benefits our courts and other sister jurisdictions.
Thank you, Ms. Vega. That's all I have.
Thank you.
Folks, thanks a lot. I'm going to ask again, are the Dorsings in attendance either virtually or in person? On my Zoom portal, I don't see any unknown numbers, so I want to give them another opportunity. I'd like now to ask, are there any other uncommitted mineral interest owners in the proposed unit that plan to participate today? In person first, is somebody in the room? Okay. In Zoom universe, is there anyone out there? I'm going to give you about 20 seconds to find the mute button.
Mick, this is Chris. One thing I'd like to mention is that with the webinar format of Zoom, We've got 3 attendees joined, and by default, they are muted. And
Well,
they
then
will not.
I'll go ahead and we'll start in the upper left. I just want to make sure everyone has the opportunity to at least say, I don't want to say anything or talk. So I have Nancy Bankhead. Chris, if you can unmute her and see if she would like to make comment. And then Nancy, you don't have to say anything. If you're quiet, we'll just move on.
Okay, I will ask Nancy to unmute.
If I may, this is Malcolm Leader Pacone. I'm attorney for Nancy Bankhead and Fallon Enterprises, Inc., the owner of the real property on which the Fallon 10 and Fallon 11 wells are located. And we're not going to be making a presentation or a statement today. We're just observing. If you have any questions of us, we're happy to answer questions.
Thank you, Mr. Leader Pacone. I do have one question. There's another one, Helen Yost. Are you representing her as well?
No, just Nancy Bankhead and Fallon Enterprises.
Thank you. Chris, let's go ahead to Helen and unmute her and see if she would like to offer any comment.
Okay, I've asked her to unmute.
Good afternoon, Helen. Well, that's fine. She doesn't have to say anything. I just want to make sure everybody had the opportunity to speak who's on our conference. All right, folks, I think that covers the parties who have signed up to speak today. At this time, if you are first in person and you would like to provide public comment, feel free to stand up, come to the podium. Again, I'm going to limit you to 5 minutes. No one's standing up in the room. Okay, we do have one person.
Commissioner, well, no, it's from the commissioners, Director Thomas.
Just call me off,
everybody.
hearing officer.
Hearing officer,
something like that.
Richard Brown with Snake River, and understand we're here to talk about just and reasonable and what will be discussed. So we're having a hearing to talk about just and reasonable to have another hearing. And I'm going to say that we, as the operator, are spending way too much money on hearings. Right now, we're spending 10 times more money on legal fees than we're spending on buying oil and gas leases and drilling oil and gas wells and producing oil and gas. So I would say that hopefully at this next hearing that we have now defined what just and reasonable is, that we can move forward and have less hearings, maybe condense the hearings going forward. Mr. Piotrowski keeps referring to that IDL is forcing these unwilling participants. And I understand that Kai represents 2 parties in this hearing, representing 1.4 acres and 1 acre. And I understand just and reasonable to me as a non-lawyer means fair, or would be inferred to what's fair. And I would question whether 2 acres in a 640 causing us to spend 12 months going through hearings on this, if that would be considered, although that's not involved in this integration, but if that's just and reasonable. But this just and reasonable term comes about, and it's used in regard to integrations, and is going to be we're going to be talking about what's just and reasonable to have an integration on this Fallon 111. So this term integration exists in almost all of the oil and gas producing states in the United States. And the purposes of integration, 2 of the most important parts of integration are it has a feature that it gets parties together. In other words, a pending integration gets parties to the table to work out terms at an arm's length transaction. In the absence of that, operators go to integration, and we have in this case. But another very important part of integration is it prohibits minorities from prohibiting the majority from exercising their rights and to enjoy their mental rights. In this case, I think Malcolm, Mrs. Bankhead's attorney was just on the phone. They're the largest owner in the unit, followed by Mrs. Donahoe, Mrs. Lochner. Next down to 60. So we've got almost 90% of the unit that want us to drill a well, and we're prevented from doing so because we don't have an integration. The other thing is, y'all just had testimony. Y'all are going to lean on other states and what they do, and why don't we lean on other states in this regard as well? So integration in other states occurs in some window of a 90 to 120 day period. In this case, we've been at this. We're going to be pushing up to over 12 months when this is done, and there's not multiple hearings. In other states, there's typically, so we've had spacing. Now we're having a just and reasonable hearing, and then going to be an integration hearing. In other states, there's typically one hearing. So if we're going to lean on other states, let's do it the way they do it. Anyway, that's all I have to say. Thank you.
Thank you, Mr. Brown. And I need to make sure that we all, go ahead. I'm not going to ask you a question.
Yeah.
That's fine. I wanted to say that I procedurally kind of broke my own rules here. I would have liked for Snake River to offer a rebuttal before the comments began. I haven't forgotten about y'all. All right. We'll get to it. But so let's go ahead and flow through the public comments, and I'll say to Snake River for your rebuttal, please don't consider any comments in your rebuttal.
Sure.
All right.
Understood.
Thank you. Thank you, Mr. Brown. Do we have any other commenters? I don't see anyone who hasn't been given the opportunity to speak yet. Anybody else in the room? Go ahead. State your name.
My name's Bob Hatfield.
Mr. Hatfield. Go ahead. I'll give you 5 minutes.
Okay, thank you, Mr. Thomas. I just wanted to say that, we have a small business here that we started here, and I've been affiliated with the oil and gas thing here since 2010. And we've been on again, off again, on again, off again. And we get on the bandwagon, we'll drill some wells, and then we'll produce some wells and complete stuff and do workovers. And we get things all get up and they start rolling ahead and everybody's doing well. And then all of a sudden something comes up that everything shuts down. And then we're shut down and now we've been shut down. We haven't really done a whole lot since they finished the Barlow and Fallon wells. And so now we've been all these years without anything going on. We need to get an industry standard. We have to keep going and get some kind of momentum going so that we have enough wells that we can say this is an industry standard. Because this is not Wyoming, it's not California, North Dakota. But we're really hanging on, trying to stay in business so that we can keep moving forward. And that's all I really want to say. My people would really like to come back home and work because we're not providing, low income jobs. We're providing jobs that are paying people $300, $400, $500 a day. When things are going on here, we can do that, but we can't do that unless this field's up and running. So we have to go other places to do it. I have people working in Nevada, they're working in Washington, they're working in North Dakota. They live here. They're all people that live in this community and they want to come home. So that's why we put all this together years ago, and then we get it up and then it all shuts down. So that's pretty much all I have to say.
Thank you, Mr. Hatfield.
Thank you, Mr. Tom.
I will say before Snake River comes up with their rebuttal, if you want to provide comments, I'm willing to accept comments up to probably, let's say 5 o'clock Mountain Time tomorrow. If you want to email comments directly into me, I just really want to give the opportunity for everyone to speak. I would say, I think on our OGCC site, definitely, yep, there is contact us. Just go to the ogcc.idaho.gov, click on contact, and we'll make sure your comments are recorded again up until 5 p.m. tomorrow Mountain Time. And with that, Snake River Council, thank you for your patience. I invite you to come up and offer any rebuttal.
Thank you, Mr. Administrator. I'll try to be brief. Mr. Piotrowski in his comments referred repeatedly to or described the process repeatedly as a taking of uncommitted mineral owners' interests and a forced sale of those interests to others. And as a legal matter, I think that's incorrect. There's a number of courts over a long period of time who have said that the integration process is not a taking. And in fact, Mr. Piotrowski's clients in the Cuyahoga versus Schultz case initially asserted a taking claim and ultimately dropped it in the case. I think because they recognized that it wasn't an appropriate claim. It is not a compensable taking. Courts have recognized that the integration or pooling process is a regulation of that interest in a valid exercise of the state's police power, which is the whole balancing act. It's sort of maybe a small issue, but I think it's important to keep in mind that what is happening is the regulation of their interest. Mr. Piotrowski continued his discussion, which carried over into his briefing or from his briefing about implied elements in the statute and what should be implied from the statute. And of course, he implied a broad range of things, up to and including an entirely separate procedure and notice and subpoena power and every other things that don't exist in the statute. And my response is really just to the extent that there are things that are directly contrary to what's set forth in the statute. By definition, it can't be necessarily implied from the statute. If 47.328 says, here is the procedure by which we will process applications for integration and the timeframes under which it will occur and who may participate and whether there may be discovery and all of those things. Those are set in statute. That's the procedure. And you cannot imply from the statute some other procedure which is well in excess and contrary to that. As to his comments about whether everything else beyond royalty and bonuses on the table, the entire universe is on the table. Again, you got to keep in mind. I think we all have to keep in mind what did Judge Windmill say? What was his directive? What was the requirement of the federal court to do to comport with due process? And that is tell people what factors you're going to consider. He recognized that the meaning of that term, because there's no definition of it in the statute, is an item of discretion for the agency, in this case for you, or his appeal to the commission. And there is abundant case law in our own state courts about what constitutes an appropriate exercise of discretion. I'm getting old enough, forget it, but a lot of lawyers can recite to me. For a court to exercise its discretion, for example, they got to recognize that it is an element of discretion. They have to engage in something that's not completely arbitrary in the manner in which they exercise it, and if you follow through those steps, you've appropriately exercised your discretion. There's no different here, which I think is why Judge Windmill did not go off into any sort of investigation or finding or order regarding what just and reasonable means, because he recognized that's not for me to say. That's an item of discretion for you, the administrator, or the commission, ultimately. And so long as you follow the rules on exercise of discretion, and you do this extra piece that the federal court imposed in order to comport with due process, you've done your job. So again, I'm repeating myself, but we need to keep in mind what is it exactly that Judge Windmill said and required, and what does the statute say about what the commission does and what its ultimate goal is, what its ultimate purpose is. Mr. Piotrowski engaged in a discussion of correlative rights, which he said included, he thinks it includes or suggests it includes the right not to sell and some other things. And again, the statute defines what correlative rights means. In making your decision and in the commission doing its job, it has to operate under the statutory definition that has been provided to it by the legislature. Because again, the commission is a creature of statute and has the power that the legislature gave it and no more. So it must use that definition. And so if its job is to protect correlative rights, that means engage in processes and do those things that it can do within the statutory framework to ensure that all interest holders have the opportunity to receive their equitable share of production, because that's the definition of correlative rights. And don't commit waste, and that also is defined in the statute. I think that's all I have to say about the opposing mineral owners' comments. With respect to Ms. Vega's comments on behalf of the department, I'm not sure, but I think we are actually now on the same page about the scope of application of that definition of market value in section 310 sub 11. I think what she said, and she'll correct me if I'm wrong, was that it applies to that definition or to those reporting obligations in 332. And so to the extent there are reporting obligations to royalty interest holders, which the integrated mineral owners will be, how that reporting occurs is impacted by the definition of market value. I don't think I disagree with that. I started with the assumption that the department was urging that market value meant something in all settings, and that, for example, it should result in a particular lease term. And I think she's maybe corrected my misapprehension. The only other comment I would have about the department's suggestions are, yes, it is reasonable to say that we should ensure that the operator complies with law. The question is whether an integration order has to proactively include terms which seek to enforce portions of the law which are already there and that the operator is already subject to. The operator already has to do things it has to do to submit an application for a permit to drill, for example, or if it wants to plug a well, it has to follow certain standards that are set forth in the statute. I think in the statute now. If it wants to, its casing has to meet certain standards and cementing, and it has to report in certain ways. It isn't necessary to recite all of those things in an integration order. It's appropriate to say, do I, as the administrator, look at the application, do I see anything that is possibly contrary to what their obligations under the law are? I think it's a very large and unwieldy and maybe impossible job for an operator to say, in the universe of laws that could apply to my application, I'm going to show you how this application complies with every single one of them. I could go on for weeks, I think, in a research project. So I think that approach isn't necessary. But certainly, if either the department in evaluating the application or an opposing mineral owner, has some suggestion that something that's included in an application is out of compliance with either the statute or the rules, then certainly the operator ought to be prepared to respond to that. But the intention of any operator, I think, in supplying an application for integration is what we've described, which is what are the economic terms upon which we're going to deal with uncommitted mineral interests, with the knowledge that everything else we do in our operations, we're subject to the law and have to comply with it. Otherwise, we're subject to penalties and enforcement from the department and the commission. I think those are all comments I have.
Thank you, Mr. Christian. And again, well, to everyone virtually and in the room, thank you for participating. I will take this matter under advisement and issue a written decision within 30 calendar days of this hearing. That adjourns our hearing. Thank you very much. Chris, you can stop recording.